Braley for questions, please.
Dr. Solangi and Ms. Super, I want to follow up on the point that Dr. Burgess was just raising, because it seems like this process was upside down and backwards from the beginning in terms of the leasing approval process and the environmental analysis, because we know that the way the courts have traditionally looked at this type of environmental impact analysis, they are supposed to have a more exacting review of that environmental impact as drilling becomes imminent, and yet the exact opposite happened here. Because we know that the multi-sale economic impact statement done in the preliminary stages of the review did examine the possibility of a larger offshore spill for these particular leases. And even though it never analyzed the impact of those spills, it reached the conclusion that a spill larger than 10,000 barrels had greater than a 99% chance of happening during the 40-year lease period under consideration. And yet, despite that information in the permitting process, a conclusion was reached by MMS that an offshore spill larger than 1,000 barrels would not have a significant environmental impact. What do you think of that conclusion? Dr. Solangi?
I think it wasn't adequate. Those were all hypothetical considerations, and really, it wasn't a well thought out process.
Ms. Subra?
I think it's almost impossible to have a spill the size that they said and not have any environmental impact. And yet, this obviously got accepted and the process moved forward.
One of the other things we know is that BP had discussed a worst-case scenario response in its initial exploration plan for this lease, which is referred to as Mississippi Canyon Block 252, indicating that it considered a potential large-scale spill. And their exploration plan said that the worst-case scenario would be a blowout at the exploratory stage, leading to a spill of 162,000 gallons or 3,800 barrels per day of crude oil. And their exploration plan indicated that their regional oil spill response plan for a worst-case scenario had been approved by MMS. And yet we know that during the hearing we had previously, the CEO of BP testified that they were capable of handling a release of 250,000 barrels per day without having a disastrous impact on the environment. And yet their initial representations is this spill we've been talking about was releasing somewhere between 1,000 and 5,000 barrels per day. So what do you think of BP's representations to MMS during the permitting process in terms of their capability of handling a catastrophe of this magnitude?
I think at this time they have not demonstrated that they had the capability of handling a catastrophic oil spill, which was a couple of 100,000 barrels. I mean, right now I believe it's more than 5,000 barrels, and ultimately, we're going to find out that this wasn't very well thought out.
Ms. Supra?
It gets back to enforcement or oversight, and if they put this forward as they were able to handle it, they should have had to have a mechanism to demonstrate they could, and obviously they didn't have the capability because this spill hasn't been contained and has caused environmental damage. So how much, as you review these applications, do you just accept as face value, and how much do you require them to provide sufficient information of how exactly they would handle such a situation?
Well, one of the things that's hard for me to understand, given the magnitude of this spill and the region it's affecting, is how a company like BP can get an exemption at the later stages of the leasing process that prevents them from having to do an environmental impact study considering all of these different scenarios based upon where that well is located. Because if you look at the regulations and the notice that MMS issued on May 1st